We have a major update in one of the most important legal challenges currently moving through the courts. This one targeting Illinois' sweeping ban on certain rifles and magazines. In a significant development, the Trump administration has formally entered the case, filing a brief that supports striking down these bans. They argue that laws like Illinois' violate the Second Amendment and are therefore unconstitutional. This case challenges the Illinois Protect Illinois Communities Act, also known as the PICA law. That law imposed a broad ban on a wide range of semi-automatic rifles, what the state classifies as assault weapons, and also restricted the possession and sale of magazines that hold more than 10 rounds. In effect, it targets many of the most common firearms and accessories owned by law-abiding citizens across the country. In the lower court, Judge Stephen McGlynn ruled against the state of Illinois. He found that the rifle and magazine bans were unconstitutional and issued a decision striking them down. The state responded by appealing the case to the Seventh Circuit Court of Appeals, where it is now pending. Illinois is asking the appellate court to reverse Judge McGlynn's ruling and reinstate the bans. In support of Judge McGlynn's decision, the Trump administration submitted a legal brief to the Seventh Circuit. They argue that these bans cannot stand under the Second Amendment, and that the lower court was correct in finding them unconstitutional. This development adds significant weight to the challenge against the PICA law, especially as the case now heads toward oral arguments, which are scheduled to take place this September. To give some background, there were originally several lawsuits filed in response to the PICA law. Multiple federal district courts granted preliminary injunctions to halt the law's enforcement, at least temporarily. However, the state of Illinois appealed those injunctions to the Seventh Circuit, which ultimately allowed the bans to remain in effect during the appeals process. That prompted the plaintiffs in several of these cases to request emergency intervention from the U.S. Supreme Court. The Supreme Court declined to step in at that stage, consistent with its usual practice of avoiding early intervention on preliminary injunctions, especially in Second Amendment cases. However, Justice Clarence Thomas issued a pointed statement alongside the court's denial. He warned that if the Seventh Circuit ultimately upholds Illinois' ban on what is arguably the most common rifle used by American civilians, the Supreme Court should be ready to review the case once it reaches a final judgment. He emphasized that the court must not allow the lower courts to treat the Second Amendment as a lesser right. While all of that was unfolding at the appellate level, Judge Stephen McGlynn continued to move forward with several of the related cases at the district court level, aiming to reach a final judgment on the merits. After reviewing the core constitutional arguments, Judge McGlynn once again determined that the PICA law is unconstitutional. He reaffirmed his earlier position, stating that the Illinois law must be struck down because it violates the Second Amendment. Illinois immediately appealed that ruling back to the Seventh Circuit. In their appeal, the state argued that the banned rifles and magazines are tools of war, primarily used in military settings, and therefore not protected by the plain text of the Second Amendment. According to the state's reasoning, these firearms fall outside the category of weapons the Constitution was intended to protect. But this case took a major turn with the recent involvement of the Trump administration. The administration filed a formal amicus brief, essentially a legal document submitted by someone not directly involved in the case, to support the plaintiffs and Illinois residents who oppose the ban. In this brief, the federal government argues that Illinois' restrictions are a clear violation of the Second Amendment and should be overturned. In their filing, the government referenced a pivotal Supreme Court ruling from just 3 years ago, which was meant to stop states from treating the Second Amendment as a lesser right, something subject to a completely different set of legal standards than other constitutional protections. Despite this clear direction, the brief argues that Illinois ignored the Supreme Court's guidance by passing a law that bans some of the most commonly owned rifles and magazines used by law-abiding citizens. The Trump administration's brief lays out 3 strong reasons why the Seventh Circuit should reverse its prior position and uphold Judge McGlynn's ruling. First, it argues that the previous reasoning in the Beavis case, another key decision upholding the ban, is flawed, even when measured against the Supreme Court's Second Amendment rulings that existed at the time. Second, the brief points out that multiple Supreme Court justices, including the author of the Bruin decision, have publicly expressed disagreement with Beavis and other lower court decisions that fail to properly apply the Second Amendment. These justices have signaled that the Supreme Court is likely to step in and correct those errors. Third, after the Beavis decision, Judge McGlynn conducted a detailed, multi-day bench trial. He examined extensive evidence and issued factual findings showing that the banned firearms and magazines are widely owned and used by law-abiding citizens for lawful purposes. Under current Supreme Court precedent, that means they are protected by the Second Amendment, and any law banning them cannot stand. These are strong and well-supported arguments, coming not just from legal scholars or advocacy groups, but directly from the federal government. The Trump administration's position is clear. States do not have the constitutional authority to enact sweeping bans on firearms and magazines that are in common use for lawful purposes. They also referenced the recent Smith & Wesson case involving the Protection of Lawful Commerce in Arms Act, PLCAA, where even Justice Elena Kagan, one of the court's liberal justices, joined in acknowledging that AR-15-style rifles are, in fact, commonly used by civilians for lawful activities such as home defense and sport shooting. Justice Thomas also emphasized this point, reinforcing the view that these types of firearms fall squarely within the Second Amendment's protections. When it comes to magazines, the Trump administration also argues that the PICA law violates the Second Amendment. In their brief, they point out that the Second Amendment protects not only the right to keep and bear arms, but also certain essential components connected to that right. As the courts have previously recognized, this includes the right to acquire arms, to keep them in working order, to purchase suitable ammunition, and to maintain or repair firearms as needed. The administration emphasizes that even though these activities may not technically fall under the literal language of keeping or bearing arms, they are fundamental aspects of the constitutional right. Based on that principle, they argue that the Second Amendment also protects firearm attachments that are commonly used by law-abiding citizens for lawful purposes. This includes not just magazines, but also suppressors and other accessories. That part of the brief is particularly noteworthy, as it reflects a strong position from the Trump Department of Justice, openly affirming that items such as suppressors are covered by the protections of the Second Amendment. This interpretation could have broader implications beyond this case, especially as future legal battles over firearm accessories unfold. While there's more detailed legal reasoning in the full brief, the key takeaway is clear. The Trump administration supports the effort to strike down Illinois' rifle and magazine bans. They've taken a firm stance in favor of protecting common-use firearms and their attachments under the Constitution. In response to this wave of arguments and the numerous amicus briefs filed by various parties, the state of Illinois requested an additional 30 days to submit its reply. The state explained that it needed more time to respond to over 300 pages of briefs submitted in support of the plaintiffs. The Seventh Circuit granted this extension, allowing the state to finalize its arguments. Now this legal battle is approaching a critical moment. The Seventh Circuit has officially scheduled oral arguments in the case for Monday, September 22nd. That hearing will give us a clearer sense of how the court views the Trump administration's brief and whether the judges are prepared to reconsider their stance. It's important to note, however, that the Seventh Circuit doesn't have the strongest track record when it comes to Second Amendment cases. In fact, the court has repeatedly ruled against gun rights in cases that many legal experts believe were wrongly decided. They've been accused of ignoring clear Supreme Court precedent from cases like Heller and Bruin, and there's little indication that the court is ready to shift its approach. In some ways, the Seventh Circuit may feel even more confident in its current position, especially since the Supreme Court recently declined to hear several emergency appeals involving similar rifle and magazine bans. But that might not last much longer. Justice Brett Kavanaugh has already signaled that the Supreme Court is aware of these issues and may be ready to take them up in the near future. In a recent statement, he noted that the time is coming, possibly as soon as the next term, for the court to review these kinds of restrictions on the merits. If the Seventh Circuit continues to uphold laws like PICA and fails to give serious consideration to the constitutional arguments made in the Trump administration's brief, this case could very well end up before the Supreme Court once again. And this time, the court may be more willing to weigh in. That's the current state of the Illinois PICA challenge. With the Trump DOJ stepping in to support the plaintiffs and oral arguments set for September, this case is shaping up to be a major test of the Second Amendment. As developments unfold, I'll continue to keep you updated. If you'd like to support the channel and stay informed on these critical Second Amendment cases, please consider subscribing. And as always, thank you for watching.